Right, good afternoon. Let's resume a few housekeeping things. First of all, I've received the conditions sent through. Thank you very much for that. Told over the lunch break that we need to be out of this room by 5. Mr. Cosgrove, first of all.
Yeah, so that is correct. I came as a slight shock to me. I didn't know that before, but yes, there's a meeting at 6, and apparently that means 5 is the deadline. But so as I hope you know, I spoke to Mr. Ricci and I asked the council officer to perhaps come and see you during the lunch break. Yeah, so there's a potential option of going to committee room 1. In theory, any time after 3:30, where there will be a sort of live link there, perhaps not quite as detailed as this, but there's a Zoom camera of kinds.
Yeah.
It's a fairly substantial committee room, nothing like this, but we could go there, and I suggest we could probably sit there to about 6 if we needed to. I wouldn't want to go in terms of council staff much beyond that, or indeed your time. Yeah. But if it were that, and who knows? But I would have thought the prospect of finishing this today, lovely as it is to be here, would be worth. If we were going to finish by 6, it would be a shame to lose that hour and come back tomorrow. So that's an option for you, sir.
And obviously not forgetting that there may well be questions from Mr. Brown. I think what we'll do is we'll take a break at 3:30, see how we're doing in terms of timing. If we can do it by 5, I'm not going to hurry anybody. I want it to be thorough but efficient. But if at 3:30 we can do it by 5, we'll do it by 5. If not, then I think at 3:30 we'll move down the road and continue after 3:30 in the new room.
So that absolutely fine. I mean, if I were nearly finishing my cross-examination, perhaps we could just stay to that. But I absolutely with you.
Yeah.
I mean, let's do that, and
yeah,
we could take a view.
Absolutely fine. I mean, the key thing, apart from our accommodation, is, and the council officer helpfully confirmed this, key thing is the live stream work. I've no idea who's out there. Doesn't matter who's out there, but it has to be out there. So let's review that at 3:30. The other thing I wanted to pick up again, Mr. Cosgrove, with yourself, was where we are on the Scouts solicitors letter that I hope you've now at least had a chance to read through.
I have, thank you. So yes, I think I would like the opportunity to respond to that. I mean, on the instructions I have at the moment, there are some matters which I'm told are not correct in terms of what has happened. And therefore, if I left it at that, you'd be getting, so far as I'm told, an incorrect picture. So what I would ask for is an ability to respond to that during the course of next week in writing. I've asked for that to be put in motion. I don't know, but clearly we have the advantage of a week before we do closings and circulate that to all the parties and you, hopefully in the early part of next week.
Yeah, that seems sensible. I mean, that letter, I think, came in on Thursday, and I had optimistically asked for a joint statement by Thursday. Didn't get that. You'd have thought I'd have learnt by now. But what I did get was 2 different pictures, obviously, and the picture from the Scouts came in on Thursday, and I've read it now. I obviously have to accept it, but I appreciate, I mean, I've seen a number of areas of concern, shall we say, putting the council's hat on, and a couple of areas where there seems to be some difference of view. Quite understand that you need to respond. End of next week in writing, absolutely fine. And obviously anything relevant to that exchange can be picked up in the closing submissions of all 3 parties. Okay, that was all that I needed to raise. So let's move straight on, Mr. Cosgrove.
Thank you. Good afternoon, Mrs. Collins.
Good afternoon.
Now, so trying to be as efficient as we can this afternoon. You helpfully took us through some aspects of the main planning statement of common ground, and I think that the battlegrounds between us are fairly cleanly set out. One of them relates to the previous inspector's decision, Inspector Bristow, NID 3.8. Now, just as I understand the position, you obviously leaving the legal aspects of that, whether it's capable of being a material consideration in this case to Mr. Ricci and his junior, and that's fine. So for the purposes, I mean, I want to just examine some of the factual matters rather as Mr. Ricci did with Mr. Johnson. but I will be asking you some questions about it. I understand your principal position is that it's not material, but nevertheless, as we go along, we'll be touching base with it on the basis that the inspector might think it is, and therefore we'll grapple with it. Okay, that's one issue. But I think we're agreed, aren't we, that the main issue between us at this appeal relates to the Para 190 MPPF test of exceptional circumstances.
Yes, we are agreed on that, yeah.
The statement of common ground characterises that as saying it goes to, quote, the heart of the appeal. And it's the determinative issue so far as you, I think, and Mr. Johnson are concerned in terms of.
That's correct. It hinges on paragraph 190.
Yeah, in the planning world we all inhabit, there are so many tests and balances, but that, so far as you're both concerned, is the key one that will answer the decision in this case. Yeah.
Yes.
Okay. Now, in your evidence generally, again, helpfully, I think you set out a scale in your proof. It's page 108. You talk about the scale you give to weighting of matters: substantial, significant, moderate, and modest.
Yeah.
Is that, so that's the scale you use in terms of when we have a document, what weight you give it? You either give it substantial, significant. Have I understood that correctly?
That's correct. I mean, I probably missed off limited, which would go before.
No, fine. It's
Yeah.
just, and it wasn't, I think at 108, which you're looking at, you said this is the scale I give to benefits.
Yeah.
But it's a general scale.
Oh, it's a general
application.
scale
Yeah.
for harms and benefits.
I thought so. That's
Yeah.
helpful. Now, first of all, in terms of policy approach then, just out of interest, and because I don't think particularly turns on this, so I'll move quickly. In page 41 of your proof, para 4.10, you give the NPPF significant weight.
Yeah.
So, I mean, just out of interest, just to getting a feel of how you approach matters, what that doesn't get your top level weighting. You would have thought it might do as a pretty recent government document that we're all
I mean, that's
hanging on.
that's a fair point, Mr. Cosgrave. I mean, I think to clarify, the MPPF is entirely relevant and should be given
Good.
the highest degree of weight,
Yeah.
particularly in the context of a out-to-date local plan.
No, fine. That's all. I'm not going to
Yeah.
say no further questions. That's my case. That
Yeah,
was just
that's
it was just a genuine query. I thought that
Yeah.
was maybe a typo. Yeah,
Yeah.
fair enough. Okay, thank you. Now, in common ground that the council I act for cannot demonstrate a 5-year housing land supply. Again, as you've helpfully referred the inspector to, that's all set out in its own bespoke statement of common ground. It's 1.28 years as the agreed figure for the purposes of this inquiry. And I think that statement of common ground, again, I don't think we need to go to it, sets out that it's now 1,481 dwellings per annum is what the standard method calculation the government's given councils produces. 710 dwellings per annum, I think. So previously 710, now 1,400. So it's a massive uplift that's appeared in the relatively recent past. Now, again, it's agreed because there hasn't been any significant under delivery of housing over the previous 3 years, a 5% buffer is applied as part of that calculation rather than the 20%. Again,
That's agreed, yes.
and that's set out, and that's in accordance with, I think, para 78 of the MPPF. And that statement of common ground set out the most recent HDT measurements, hasn't it? In table 1, so the inspector can see that. Yeah. Okay. Now, I think we, again, in fairness, you would agree, wouldn't you, that supply figure we have, the 1.28 years, has got to be understood in context. We may have different views as to what the context it is, but it's got to be understood in context.
Yeah, I don't disagree.
And let me just let me put some of the matters I'm going to suggest to the context to you, and you tell me if you agree or not. One, of course, it's been arrived at very recently with the new Labour government and the new MPPF and the new requirement to calculate under the standard method as it now is. Yeah.
The standard method is new as of December
Yeah.
last year. Yeah.
And again, let's cut through some matters that are not in dispute between you and I. Mr. Johnson can close his ears for a minute. So I'm going to deal with some matters of law. But for decision making, because there's no 5-year land supply, it means that when we look at paragraph 11D, that is engaged in the sense that footnote 8 defines that the most important policies will be out of date because of the lack
Correct.
of fibre supply.
Yeah.
Okay? And it's right, of course, even when one sort of wonderful world of policy language we have, I'm not quite sure how lay people are meant to follow it, but even when policies are, quote, out of date in the sense set out in 11D, the weight to be given to the particular policy in question is quintessentially still a matter of planning judgment, isn't it?
That's correct, yes.
And in part, the courts have made clear that that exercise can relate to the consistency with the given policy with the NPPF.
Yeah,
And it can relate to other matters, the particular context of the site in question or the particular character of the application in question, for example.
as a matter of planning judgment.
Yeah.
Yes.
So that's helpful. There's now nothing between us then the 190 NPPF and the answer as to whether there are exceptional circumstances and whether or not it can be demonstrated that the development is in the public interest goes to the heart of this appeal. Now, just putting it one way, and obviously the converse is true. I think you set out the converse in your evidence in chief, but you accept, don't you, that this what is agreed to be a major development proposal in NPPF terms before the inspector should, in accordance with para 190, be refused, therefore, unless you are able to demonstrate there are exceptional circumstances so as to allow it.
190 says, as a starting point, it should be refused. I
Yeah.
agree with that, unless exceptional circumstances apply.
Yeah, so I'm saying because we've all agreed that
Yeah.
as it happens in this game, in other cases, it might not be the determinative factor, actually. Perfectly possible to think of in planning any scenario, but in this case, I think we're agreed it is. So onus on you, isn't it? Unless you can demonstrate there are exceptional circumstances. Incidentally, let's get rid of this point. There is the important, not to be forgotten phrase, and in the public interest, but I don't think there's any issue between the parties in this case that if there are exceptional circumstances, it will be in the public interest and vice versa. Okay, so.
I think on the basis of other appeal decisions and case law.
Well, fine, but I mean, it's a point in your favour. I mean, okay. So, but that's right, isn't it? Unless you can demonstrate the exceptional circumstances, this inspector, in your judgment, should refuse the appeal.
That's correct. We obviously, we have regard to footnote 67 as well, and that obviously major development isn't defined in this particular case. The parties accepted this is major.
Yeah, we don't need to worry about that, do we?
So
We
we don't-
agreed it's major.
Yeah, that's fine. Just
Yeah,
checking.
so,
the footnote.
and we could hold a whole, we could have a whole, no, let's just agree it's major.
Yeah.
Now, just take that a stage further. If the conclusion therefore is on the evidence reached by this inspector that you haven't demonstrated there are exceptional circumstances, it's right, isn't it? The indication he finds in para 190 that the proposal should be, quote, refused, plainly provides a strong reason for refusing the development proposed.
Yes, it's a converse of our case, but
Yeah.
as I've said, the case hinges on exceptional circumstances.
Yes,
Yeah.
and I'm not trying to trick you. The reason I use the phrase strong reason is the wording in 11D that we now have in 11D1, isn't it?
Yeah.
And again, 2 points really. Government policy could hardly be clearer in terms of 190 and what the decision maker should do in the event that there are not exceptional circumstances. And although you had a little debate in your proof, and I don't mean that in a patronising way, for report 415 of your proof, you gave some evidence to the inspector as to the difference between strong reason now and clear reason in the previous version of the NPPF. And I think Mr. Marici asked Mr. Johnson about that, and you may have mentioned it briefly in your evidence in chief. But actually, when you cut down to the issues in this case, it doesn't really make any difference, does it here? Because we're agreed that if there are no exceptional circumstances, and there will be a strong reason to refuse.
Well, it is a slightly different way of putting it, Mr. Cosgrove. But if you look at 11D2,
Yeah.
obviously that says any adverse impacts of doing so would significantly and demonstrably outweigh the benefits.
Yeah.
Which is obviously below 0.1, and you read them both together. I think you need to, because you read the NPPF as a whole, you're viewing paragraph 190 through the lens of is there some significant, substantial harm which would provide a strong reason to refuse in that particular instance. So I mean, it goes to, for example, 190C, which talks about any detrimental effect on the environment.
No, I think it's no doubt me being unclear. I thought this was absolutely crystal clear between us. In the event, I know it's not your case, I'm not going to, in the event that there are no exceptional circumstances, say that 190 indicates should be refused, all I'm suggesting to you, that is about as a clear example as you can get when one goes back to 11D of there being a strong reason for refusing.
Well, put that way, that's, yes.
Yeah, so my point is, in this case, there may be cases, there is already some emerging case law in other areas to do with flood risk where there isn't such a inherent balance. But in this case, we're agreed that if 190 falls in the favour of the council, that would provide a strong reason for refusing development. And the converse is true. Yes, right. So we don't really need to trouble the inspector with the difference between strong and clear on the facts of this particular case. Interesting, fascinating, as it may be for lawyers to do so, it's not really going to assist this inspector, is it?
Well, obviously, it relates to footnote 7, which refers to national landscapes. The applications of policies favour protect areas of assets of particular importance, provides a strong reason for refusing development proposed. If there's not exceptional circumstances, then permission should be refused on the basis of 190.
Yeah, and on the basis of 11D, in other words, there would be a strong reason for refusing the development in terms of 11D1. Yeah, that's all. That's all. I mean, I thought that was not controversial. Okay, thank you. And of course, in that event, that's another way. That's in NPPF terms, the policy would then be, quote, an unsustainable one, wouldn't it?
Sorry, the
Policy
proposal
would be unsustainable if you're working out in NPPF terms whether something is sustainable or unsustainable in development control terms.
Yeah.
The answer's found
Well,
by
if
the
the
answer.
overall conclusion of all the policies and the analysis of the NPPF is to refuse, then
All right,
yeah.
good. Now, that's helpful. Now, if the local planning authority's case is accepted, and there are, and you've helpfully highlighted a lot of differences, some of which we'll touch on in terms of landscape evidence and the approach to 190 generally and other matters. The LPA case is accepted and the exceptional circumstances test is not met. Your position is, I think, you accept the appeal scheme would not be in accordance with the development plan taken as a whole.
So if there's not exceptional circumstances, then clearly there'd be a conflict with RE3, which is a most important policy.
Well, not quite what I'm, and to be fair to you, I don't think that's right, actually, but that's a point in your favour. But really what I'm putting to you to try and cut things down is, in the event, in the scenario which we're all grappling with, that there are not exceptional circumstances, I don't think, as I read your evidence, there's any issue that, in your view, the appeal scheme would not in that event be in accordance with the development plan taken as a whole.
Well, I would assume in that particular instance, there'd be conflicts cited and give more weight than I would attribute to various other policies.
Yeah, I mean, there could be a number of ways of getting there. There could be conflict with some policies, not with others. There could be.
There's plenty of routes.
But your overall position is, as I understand your evidence, in that event, taken as a whole, judgment would not be compliance with the development plan as a whole. Is that fair?
I think it's a difficult one to answer because you're going on many routes to the same destination, because it depends on which policies are conflicted with when you make that conclusion.
Well, I tell you why I don't think it's difficult, because you take the opposite view. You say that if there are exceptional circumstances, that the development is complied with as a whole. So I'm really just putting the opposite position to you out of fairness. That must be right, mustn't it? The opposite must apply on your own logic.
In this instance, and
well, that's all I'm interested in. I'm not going to ask about other, for the purposes of this case.
for the purposes of this, yes.
Yeah, all right, thank you. All my questions are really just focused on this application. Excuse me. Now, good. And in that event, in the event that the 190 test goes not test, forgive me, loose language, the 190 considerations go the way the council said they should go, you're not suggesting there are any other material considerations of sufficient weight to indicate a determination otherwise than in accordance with the development plan?
No.
Thank you. Right. Good. Now, with that in mind, I think that's helpful sort of structure of what we're all agreed on. And incidentally, on nearly all of those points, the opposite would be the case if there are exceptional circumstances from the council's position. But that's the sort of structural battleground between us. Now, I want, with that structure in mind, look at some contextual considerations about the government policy that I'm going to suggest to you are relevant to the issue of whether in the round the inspector comes to the view there are exceptional circumstances or not. Okay, that's the focus of the following questions. Now, in the context of, in particular, housing delivery, and I appreciate you're proposing to do other things like scout huts, but I'm going to focus initially on housing. In the context of housing delivery, it is important, isn't it, to understand how and where the government wants much needed market and affordable housing to be delivered. Is that fair?
Yes.
Yeah. And that understanding of how and where would be important. And one of the important things for the inspector to be thinking of when he's thinking of, for example, 190A and national considerations, that general phrase, is that the decision maker should be aware of. Yeah?
Yeah.
And obviously we've talked a lot. We know there's a fairly new MPPF, made significant changes, some of which address those issues of how and where the government wants the 1.5 million houses that are needed to be delivered. It's fair, isn't it? So, and I don't think you're suggesting this, but just for my note, it's not as simple, is it, as saying there's a new standard method, there's a new need identified in an area, and developers therefore have carte blanche to go on some kind of building spree wherever they like. I mean, I don't think you're suggesting that.
Well, no, because
No.
there's
All right.
there's policies for and against development.
Exactly. Exactly. Yeah. Now, part of the context, therefore, let's look at in terms of up-to-date national policy about where you should develop housing, and how you should do it. Now, can we just accept some of the points? We can delve into documents if we need to, and otherwise we can move on. I'm entirely relaxed either way. Would you accept that in principle, when one looks at the MPPF and government policy generally, decisions in an ideal world, let me put it this way, decisions as to where houses should and shouldn't go, particularly in sensitive areas such as national landscapes or national parks, should be plan-led?
I accept we still have a plan-led system.
Yeah.
In England, in theory, yes.
Well, yeah, I mean, it's still, you know, the government could easily, they weren't shy of changing quite a lot. And we, you know, we look at para 1 of the MPPF in its latest forms, couldn't be more clear in that regard about the importance of a plan-led system. Okay. Could we just turn up NID document 7.1, which is the Secretary of State and Deputy Prime Minister's ministerial statement, which she delivered in July.
24.
So just to give a little bit of context, obviously a few months before the new MPPF was published. And I think we may have looked at this already, but if we go to PDF page 1, if you're looking at electronic copy, I know you've read this, so can I go, rather than go through it in detail, cut to the chase on particular points? Under the heading restoring and raising housing targets on PDF page 1, you'll see there's a paragraph saying planning is principally a local activity. Do you have that?
Yeah.
And it's right that decisions about what to build and where should reflect local views. But we are also clear these decisions should be about how to deliver the housing an area needs, not whether to do so at all. And these needs cannot be met without identifying enough land through local plans. And then so there's the reference to local plans. And then if you go down to PDF 6, we'll track back and look at some other bits in a minute. There is a paragraph beginning under the heading supporting local planning, refers to reforms, and then the second sentence, the plan making system is the right way to plan for growth and environmental enhancement, ensuring local leaders and their communities come together to agree on the future of their areas. Once in place and kept up to date, local plans provide stability and certainty, but local people and developers want to see our planning system deliver. And then it goes on saying too many people haven't done local plans. So it's quite clear, as I say, reflected in the published NPPF, but clearly in the Secretary of State's mind in the run-up to publishing the NPPF, the importance of a local plan-led system. Yeah?
Yeah, that's the government's intention.
Yeah. Now, that, can I suggest to you, just as a matter of principle, and I think you may have accepted this at the last inquiry, but you tell me if you've changed your mind. That's particularly important when you're dealing with sensitive areas such as national landscapes. And I'll suggest to you why. It's because forums like this are not ideal, are they, for resolving whether and to what extent land should be developed in a national landscape. It's not a great way of doing it, is it?
Well, I suppose the optimal way of doing everything I accept is through a plan-led system, up to date. Plans are supposed to be kept up to date every 5 years, as we know. Does that happen in reality? Well, certainly not here. And in a public inquiry, development management public inquiry, you need to use the evidence that's available to you.
Yes.
Which is, given the stage of production of the emerging local plan, so is relatively limited.
Well, absolutely spot on. No, I'll come back to that. And just as a flag for you to think about, and I'll aim to get out of here this evening. Questions coming in about an hour's time. Some of the decisions which you rely on, where there have been grants in the national landscape, as it happens, and I'm going to suggest to you in due course as your headline coming your way, and no coincidence, that they are in an environment where there's a very well developed local plan process, almost at its completion, Turndon, gone through the whole process, and there's emerging allocation about to plop onto the development plan. That situation, yeah, absolutely. But in the case where, for whatever reason, in this case, because there's a brand new government policy a few weeks ago, and this local authority, otherwise, have got to now grapple with that afresh, concept of grey belt. Yeah. In that scenario, this is not an ideal forum, is it, to start working out which bits of a national landscape, highest designation along with national parks in the country, should be built on. It's not ideal, is it?
Well, it's what we're having to deal with, obviously, because there is an absence of an emerging local plan, and there won't be the evidence for a few years, I would suspect.
Yeah.
But I mean, obviously, regardless of wherever the local plan is at, a major development in the AONB, sorry, the national landscape, is going to need exceptional circumstances.
Yes,
it's a development management test.
Yes, you keep making that point, and that's absolutely right. Absolutely right to make the point. But you will appreciate, and again, we'll flag up what's coming. You look at how important the fact of an emerging allocation was to finding that exceptional circumstances case to the Secretary of State in Turndon. I mean, it's a key factor in asking whether, well, the exceptional circumstances in that case is this is about to become an allocated site in the development plan, fairly exceptional. If I'm deciding whether to develop a bit of the national landscape, yeah?
It's one of the factors.
Well, it's the key factor in that case. And so, yes, it is relevant. But if you're an allocation or an emerging allocation at an advanced stage in a national landscape, a lot of the legwork has been done, and so the decision maker can have confidence that alternatives have been looked at comprehensively through a local plan process. And that's relevant to whether there are exceptional circumstances. Now, in this case, put aside the reasons, because it's not, I mean, I act for lots of developers. I don't think it's helpful to necessarily, and I'm not suggesting you are, councils do their best in difficult circumstances. We're at the start of a process. Yeah, we've got a timetable. We're at the start of a process.
The process should, the complete answer to that is the process is underway already. It should have started a few years ago, but we are where we are. We're talking about the emerging local plan. process here, of course.
Yeah.
Um,
Well, okay.
But so, but there is, I mean, factually, there is no Reg
Yeah.
18, there is no draft plan.
You keep saying that. How long is it since the government has published, for example, the grey belt policy,
So,
which is fundamental to
no,
delivering?
So it was draft in July last year, and
Yeah.
it was policy from December.
And the guidance, which I think everyone would
February.
accept, February the 27th.
Yeah.
So about 8-9 weeks ago.
Yeah.
Right.
So,
Okay. So you expect this local authority to have done a fully grey belt review through their district in the last few weeks, do you? This is just not credible.
so,
Of course they can't.
of course, I agree with that point. It's fine, but there's not been a law for 5 years. There could have been one in the intervening period to update. So, yeah,
Well-
and some various other bits, issues and options consultation, that'll be one of those. So more progress could and should have been made, in my opinion.
Right. Well,
But-
we disagree, and I will come back to that timetable with you, and you can tell me why this council's being slow, if that's what you think it is being. But I think we can agree, I think we have agreed, hopefully, that in principle, the plan-led system is the right way, particularly in sensitive areas like this, to decide whether major development should be placed on the national landscape or not.
So I'm happy to agree, ideally, yes.
Yeah.
But
Okay.
as we know, that the planning system operates in both policy and development management, so
Yeah.
decisions still need to be made in the short to medium term.
Because, and then this is all relevant to whether there are exceptional circumstances in this case. Because you see, having a plan produced and you saying to the inspector, pointing to the inspector and saying, well, there's not a lot down there, not a lot in Cranley. I mean, that's not a way to decide, frankly, whether 5 hectares of national landscape should be developed on, which Bayside accepts is going to cause harm.
Well, as we've discussed already, context is key. I think in deciding the scope for developing outside of the designated area, the geography of the entire borough is relevant. So, and for the inspector to
Yeah.
have an understanding of that geography.
But absolutely. Okay, now. And to pick up your point, let's just, before we leave NID 7.1, if you go PDF point 2, I hope in fairness to you,
Are we still on the same NID, Mr. Cosgrove?
we are,
Yeah.
7.1, yeah.
Yeah.
So PDF page 2. And the penultimate paragraph, so it's very annoying this because it's not paginated or paragraph numbered. So there's a phrase, and this may be picking up your point about, you know, what do you do when there isn't a local plan? So
Yeah.
see, but we cannot wait. So, but we cannot wait for all release to come through plan making. Where authorities are underperforming, be that lacking a sufficient supply or failing to deliver through enough aims as measured by the housing sector, we will therefore, excuse me, also make it clear that applications for sites not allocated in a plan must be considered where they relate to brownfield and grey belt land.
Yeah.
It's not you, is it?
No, we're not brownfield or.
This
green.
route will maintain restrictions on the release of wider greenbelt land, meaning it would remain possible for other greenbelt land to be released outside the plan making process where there are very special circumstances exist. In such cases will remain exceptional. You can see that here the lawyers wincing between very special circumstances and exceptional. But and then it goes on about strengthening the general presumption in favour of simple development. So clearly the government has in mind cases because they're not uncommon, where local authorities haven't got up-to-date local plans in place or at the early stages of a plan review. And incidentally, in light of the changes about brownfield and grey belt, a lot of local authorities are having to start again, effectively, to find these areas. And I'm going to suggest to you, and some other references will come to, that the government is pretty clear that their strategy is to primarily focus in those situations on applications for brownfield and or grey belt land. That's the policy they're pursuing.
Primarily, yes.
Yeah. Now, we'll come on to it because you say, well, yeah, and you're absolutely right, there's the exceptional circumstances test and 190s remain the same, and it's been the same in different paragraph numbers for lots, probably since the year dot. I mean, Marie, she's much older than me, so you'll remember.
Before MPBF 2012, yeah.
Pardon? But I thought I'd get that in. But My filibuster you. So, what has changed is the context around the exceptional test. That's the point I'm putting to you. Because the government hasn't just said, well, we're going to just keep the national landscapes protection the same. They said we're going to keep it the same and we're going to identify how and where the 1.5 is going to be delivered. And what I'm suggesting to you is that primarily that's not going to be by using national landscape land, except in exceptional circumstances. But when you're understanding what exceptional means, you've got to understand the context of how they want it to be done. You see?
Okay, I can see the point
Mhm.
you're making. If I think just to counter that, I accept that previous iterations of policy was about brownfield first. It's been brownfield first ever since I was a junior planner. It was brownfield first and greenfield, to be fair, application of 5-year supply on normal greenfield land. What has changed is there's been a softening, in inverted commas, of greenbelt policy, introducing grey-belt. That is a change, I accept that. But whilst those things have changed, the policy on national landscapes has remained the same. I accept that. But there's not been a strengthening of it. It's just stayed the same. You can build in exceptional circumstances.
Yes, whether there's been a contextual change which is relevant to how you apply it depends on the circumstances surrounding. Because you see, what I'm suggesting, let's look at brownfield. I mean, you all know there have been quite material changes to brownfield. Yes, there's always been an emphasis on that, but the NPPF amendments have made it far easier, haven't they? If we go to 125, and this will be played out, no doubt, in the months to come.
NPPF 125.
NPPF 125, making effective use of land, section 11. I mean, you all know this. One of the big changes, 125 little c, gives substantial weight to the value of using suitable brownfield land with settlements for homes and other identified needs, proposals for which should be approved unless substantial harm would be caused. So that's a new test that's been inserted by this government.
Yep.
Pretty good one if you're wanting to develop on brownfield land. You're going to get unless there's substantial harm, and we all know what substantial harm can mean when lawyers get their teeth into it. So, I mean, that's a material change to government policy, isn't it?
Well, it's a new paragraph, I think. So yes, it is.
Your clients of brownfield land must have been chomping at the bits, and they saw that.
Well, those that have brownfield land which either isn't contaminated or in a conservation area or affected by a listed building, because their heritage policies haven't changed, as you know, which are often a barrier to regeneration schemes.
But you see the point I'm making.
Well, I mean, context is. I agree, context is important, and yes, they're seeking to focus more on brownfield and grey-belt and other greenfield, but allied to that, the needs of development have gone up too. And so is the emphasis.
Yes.
So the government is seeking an ambitious growth agenda.
Yeah, absolutely.
There's more to plan for.
But the point I was making earlier on in the inquiry of not detaching the 2 points. Absolutely increased identification in need through the standard method and the 1.5 aim. And then there's the other side of it, which is how we want to deliver that, how we want to do that. And if you can't just detach that, if you just take the need, the danger is you'll have people going off and trying to build in the national landscape, Mr. Collins. That's the danger I'm worried about, you see.
I can assure you it's not that easy.
What I'm suggesting to you is the context, and I'm being rather laborious here, but we will speed up. So the government saying, well, this is how we want to do it. We want to do it brownfield, and we've amended the NPPF, and we want to do grey belt. Come on to that in a minute. So if one just looks at, we've looked at some of the policies and the ministerial statements, and you gave some evidence in your proof about the 7 to 12% of land. I mean, that might, it's a very, I know it's a rough and ready percentage. It's the nature of these kind of forums, Section 78 appeals. I think that was the figure, 7 to 12% that might exist in a world where if you took away all the green belt or national landscape land, including what was proposed to be extended, that's what you might be left with.
But that figures come from Waverley. That was a councillor statement. Yeah.
Yeah, I mean, you put it in your proof.
I know, which is approximately happy to accept the figure.
Yeah. So that's fine for me.
Yeah.
If we're working with that, and inspector's got some little visualization of that to some extent.
Yeah.
talking very broad terms. But that's, obviously that statement you quote from, I think the inspector will remember it, so we don't need to go to it, was made last year. It was before grey belt, as we now know it, exists, particularly in the last 8 weeks when we've got the, I think you would agree, most planning consultants do quite significant PPG guidance on what grey belt actually means. And we can get even more excited about now. The Court of Appeals told us that in some circumstances, PPG can have as much importance and force as an MPPF policy. Yeah.
You're referring to the Mead case.
So throw that in the mix.
Yeah.
And that is, again, most commentators would accept as part of the government policy, opened up perhaps much more potential for grey belt land than otherwise people thought.
I agree as a point of principle, there is scope
Yeah.
now
So,
on grey belt. Yes.
Now, we're at a Section 7 appeal, but I'm going to suggest to you this is not a flight of fancy or speculative for the inspector to be aware that even if he's only working with 7 to 12% of the district, and the news policy out a few weeks ago, new guidance telling clients such as yours and councils what grey belt land might exist, there's a lot of potential for sites to come forward that wouldn't otherwise have been able to.
Well, I don't know if we can use the word a lot, but there is potential for sites to come forward.
Yeah, okay.
So I did it in my evidence in chief. I identified the parts of the district. You can see them on the plan where you could, in theory, have grey belt. But
Now, that's fair. And look, no local authority, I mean, I don't think you're singling away, but no local authority could have, in the space of 12 weeks, done a district-wide review of grey belt land and produced a document for clients such as yours to look at or to work on, could they? I mean, it's just ridiculous to suggest they could have done.
on grey belt only, I agree with that.
Yeah, but that's one of the key strategies of the government's policy to deliver 1.5 houses. So this council, as you've heard, has decided, right, we've got this, we've got Brownfellow, we're going to redo it to take account of new policy. And that's what they're doing. We've got the timetable. One thing everyone keeps ignoring, but I'm going to flag up in the timetable, it's set out in the Statement of Common Ground, is what's happening in about 4 weeks, which is what's called the process of engagement on the scope and content of the plan. Could have called it a call for sites, I suppose, but it's called engagement. That's a process that's going to ask people such as yourselves or clients you may have to engage in light of the new policy, isn't it?
You're referring to paragraph 3.8 of the Statement of Common Ground. So consultation during the preparation of a DPD, consultation on preferred options.
Yeah, it's in the, I think it is in the Statement of Common Ground. 3.9 was my note, but you may be right.
No, it's 3.9. Sorry, that's the old time frame.
Yes, the new time frame I'm looking forward to.
3.8 is the old one. 3.9 was what council executive agreed to.
Yeah, a few weeks
last
ago.
month. Yeah.
About just over a month ago. So we've got early summer. I think the website now says June, but engagement on visioning and the scope and content of the plan. That's a process that's going to invite, well, you know, we all know what engagement means. It's going to invite people to get involved with and offer new sites.
Yep.
So that's, I mean, so that's within a few weeks of the government publishing PPG on what grey belt is. That's not being slow, is it?
The council could and should have produced an earlier draft of the plan, in my opinion. You could obviously do as many regulation 18s as you want, as we all know, to react to changing circumstances. We just do not yet know what is going to come out in that consultation. We'll know on the basis of these timeframes by June, I think you just said.
Yes, but Mr. Collins, if the government, as we accept, radical new policy in December, since then, more detail about how they want brownfield and grey belt land to be identified and delivered. Councils up and down the country are having to stop and review their local plan and do more work and assessments. Of course they have to. It's what the government's telling them to do.
Yeah.
I'm suggesting to you that the process of engagement that's happening in a few weeks further to that is about as speedier an operation as any council can do.
well, in the context of Greybelt only.
Yeah, which is
yes.
which is the context of your
Um,
1.5 million hound. That's what the government want us to do.
yeah, well, the government wants 1.5 million homes on Greenfield, Greybelt, Brownfield.
No, Brownfield Grey Belt.
No, yeah, so, and,
Brownfield Grey Belt.
well, and normal green.
And
Greenfield.
then, yeah, well,
Yeah.
wait, yeah, a long queue before we get to national landscapes, let me assure you. But there we are. And so can I just suggest to you to move this on, that the timescale for the local plan is realistic, and it involves a process in the next few weeks where clients such as yours can engage, and sites in the 7 to 12% for Grey Belt, Brownfield can come forward. And that's where we are.
So in the context of Greybelt, yes, but I just would note, I mean, so you got the evidence from the first inquiry, there wasn't a 5-year supply then, and that was based on a lower standard method. I think it was about 710.
Yeah.
And back then, 12 months ago, and before that, the plan was out of date. So the council could have started local plan production 2-3 years ago and didn't.
Yes.
I think that's relevant.
Okay, all right, I hear what you say. I don't agree, but that's fair enough for you to make that point. Now, it's also right, if that timetable is followed, you say it's going to be 2029, you think it's more realistic.
Yeah.
I don't think that's right, but anyway, that's an issue the inspector can think about. That's the considered timetable the council have put forward to adopt by July 2028. So it's right, isn't it, that the requirement for housing that process might identify by 2028 could become clear then in a relatively short period, in about 3 years. That requirement, the actual requirement for housing identified, having gone through a plan process, could become clear by then. And in fact, an emerging evidence base will exist long before then.
On those timeframes,
Yeah.
then that's factually 3 and a bit years. I've
Yeah.
already said in my evidence in chief, I think examination would take longer, sir. The only, well, the key side issue is devolution, and how that plays out. Waverley will not exist as an authority in about 2 years' time. This is probably going to be the West Surrey Authority or a complete Surrey Unitary. So we'll see what
Yes,
effects that
sure.
has on plan making.
Sure. Well, as Mr. Johnson said, the inspectors with plenty of examples of that happening already, and keep their own local plans in under the new umbrella.
Yeah, that could be one approach.
Happens where I live. Yeah.
That could be one approach.
Okay. So that on your timetable, it's a year later. Okay. And we'll come on to deliverability. But if I'm right, so I'm going to put you later on that, and as I think you accepted the last inquiry. But anyway, your scheme. I'll give you this. Your scheme may well deliver the lodge if it gets permission within 5 years. But beyond that, I'm going to suggest to you it's unlikely that there'll be any material delivery of housing within 5 years on your site if it gets permission.
I don't agree with that.
Don't agree with that. If I'm right, I'll come on and grapple with you that a little bit later. We'll look at Litchfields and so forth and your evidence. But if I'm right, in fact, the actual requirement for the local authority and identified sites and evidence base could become clear well before your proposal would actually deliver any housing.
If you're right.
Yeah.
So if you're right on the adoption, which is summer 28.
Yeah.
Then yes, on that proposition.
All right. We'll come to deliverability. I know you don't agree on the 5 year, so I'll come back and let you have your say, and I'll have my say on that. Now, fine. Okay. Good. So I'm just going to save some time by cutting some matters out. So can we just agree then, in light of that little debate, to be fair, it would be artificial, wouldn't it, for the inspector to assume that the only sources of supply are those which it's possible to identify at this point in time as we sit here now?
Well, the inspector has before him the evidence that's before him, which is a 5-year land supply deficit of 5,770 dwellings, and the limited alternatives list that we've agreed, the appellants and the council have agreed.
Yeah.
The inspector can't give any weight to unknown sites which have yet to come forward through the plan making process or an updated law.
No, that's not what I'm asking you. I mean, given that you've accepted a moment ago, there is at least potential for sites to come forward in the grey belt new policy. What I'm putting to you is it would be artificial. You may say it's the only evidence he's got, but it would be artificial for the inspector to assume the only sources for supply are those which it's possible to identify at this point in time. That would be an artificial exercise.
Well, I mean,
So yes or no, and by all means caveat.
I think it's, it is, I mean, what's the yes or no for that? I mean,
So you can say yes, yes, it is artificial, no, it isn't artificial.
Yeah, yes, it is artificial, but to qualify, you can't just you can only determine its application on the evidence before you, and the evidence of the sites are what is known about today. There is, I mean, what you're suggesting, Mr. Cosgrove, is there's a prospect for more sites to come forward.
Yeah.
That indeed, I accept, is what the government is asking and what the council is no doubt asking for, call for sites.
Yeah.
But, you know, I mean, indeed, many sites do need to come forward, sir, because as we know, the shortfall is pretty substantial.
Yeah. And as you've accepted, there's the potential for sites to come forward.
Yeah, of course
Yeah.
there is. Yes, I don't disagree with that.
Yeah.
There's a potential. Is there the evidence that they exist or they are coming forward today? No. Is there potential? Yes.
And of course, that's the last inspector took factors like that into account, didn't he? In his decision.
What are you? Which bit are you referring to, Mr.
So
Cosgrove?
para 155.
One for-
So I'm going to, me going too quickly, I'm assuming.
So sorry, I'm just to make sure I know which bit you're talking about. So
No, fair enough.
so the inspector there accepts that plan making has not been quick. So you're referring to the last line of that? In short, there are some.
Yeah, so obviously put ourselves back then, he wasn't in the same stage now because he didn't have the new government policy, but at that stage, the evidence for there being a call for sites, there was no results as yet before the inspector, that's where they were. He thought the timescale was a bit optimistic. But he said, but he formed a judgment.
Yeah.
That there may nevertheless be scope for other sites to come forward before the end of the plan period as a result of that process. Right? It's a judgment. He was open to make it as a planning judgment, as I'm going to suggest. We've slightly got a different policy context and a different timetable, grey belt, all that stuff. But I'm going to suggest this inspector is perfectly entitled to form such a judgment as part of the 190 exercise. That's all I'm putting to you.
Oh, I see. Well, I mean, yes. In terms of just to qualify that, you'd obviously make that assumption, sir. It is an assumption based on the evidences before you.
Yeah.
I think what's notable about that paragraph is that there's been no progress on the local plan. The situation is virtually the same now as it was when.
Yes, Mr. Conchi, you keep saying that, but you are ignoring the fact that the government have changed policy radically. I mean, everyone accepts it's been one of the most radical changes in policy, and so local authorities have had to stop and recalibrate and start again. So you keep sort of laughing with great respect, saying, "I can't believe there's been no progress made." There's new policy, there's new definitions of grey belt, new approaches to brownfield. Councils have got to stop, as this council's done, and start again and engage. Got to do that. It's not them delaying. They couldn't have. They published something last year. They'd have had to rip it up and start again.
Well, if they'd published something last year, we'd have more information on alternative sites probably, because there'd be an up-to-date law. But my point was in response to that, I accept there's been a change of government policy. Yeah, I accept that, Mr. Cosgrove. But there was a need to do a new local plan 2 or 3 years ago, because even based on the old standard method figure, which was just north of 700 a year, there wasn't a 5-year supply.
Good. All right. Thank you. Now, another, what I suggest to you, pretty fundamental point. We grapple with a few contextual matters, as it were, the mood music within which one has to consider. I'm going to submit in due course 190. A further fundamental point is that the plan-led requirement that this district ends up with, whether that's in 2028 or you think in 2029, may well be far less than the standard method used to calculate the current 5-year supply. That's right, isn't it?
It could be less, yeah, as a policy on. constrained figure
Yeah.
tested.
Well, it may well be far less, is what I'm putting to you, given the particular constraints which you helpfully identified in your plan you produced this morning. May well be far less than the standard method calculation before this inspector at this inquiry. It's fair, isn't it?
I mean, we simply do not know. So it's clearly it's a matter for the council to consult on and then put to an inspector for an examination, a policy on constrained figure.
Absolutely. Well,
Yeah.
so you don't, I mean, you can say you don't know. Fair enough. I put it to you twice. If you, Mr. Johnson's given an answer on it, but I'm going to suggest to you that is a proposition which is true. May well be far less than the standard method. And that proposition is highly relevant for this inspector to consider, isn't it? In the context of the planning balance he has to undertake in this case, and in particular, the considerations he is being asked to grapple with in 190A of the MPPF. That's fair, isn't it?
Well, I don't agree with that entirely. So far as the present need, and the need is obviously in 190
Yeah.
is stated, is the standard method,
Yes.
because there is no up-to-date housing requirements. So whether or not that number, which is, as we know, just north of 1,400 a year, goes up or down, it could go up in theory, but I hear your proposition that it could go down. That's immaterial at the moment. We just do not know that.
You think it's immaterial, and that fine. I'm going to suggest I'm really suggesting it's highly material, but it's a matter of planning judgment. Your view is it's immaterial. I'm pretty sure. Let's see. I mean, we may need to go into a little bit of case law and try and avoid that, but let me put some propositions to you. If when one looks at the shortfall at the moment, in other words, the new standard methods come in a few months ago, was double the amount. It's wholly unsurprising that there's currently a shortfall in this district, isn't it? Do you understand what the government's trying to do? They've massively increased the calculation to engineer a huge, great need, and they set out a policy of how they want that delivered. So it's wholly unsurprising if you go to someone like Waverley, and you can repeat that throughout many districts and boroughs throughout the land. Wholly unsurprising, there's a shortfall at the moment.
So the imposition of a higher standard method does increase the shortfall.
It's not a
Yeah.
front page news item, is it? I mean, you know, local authority doesn't have 5-year land supply. Wholly unsurprising at the moment. Yeah. And I won't be cheeky and say not exceptional. I'm just going to say wholly unsurprising. Let me put this to you. This inspector could properly conclude, couldn't he, that some degree of shortfall, given the latest standard method and policy, some degree of shortfall in this local authority is almost inevitable. And as a result of that, the weight that he gives to that shortfall as a material consideration could properly be reduced. That's the proposition I'm putting to you.
Okay, well, I think to answer that fully, so in evidence in chief, I introduced the trajectories in Mr. Neam's analysis. So that's trajectories 1 through to 5. If you look at his trajectories 1, 2, and 3, those conclude a shortfall over the plan period 2013 to 2032, applying the requirement from the local plan in the first period to 23-24, sorry, 22-23, and that requirement's 590, policy on, to the constrained requirement. And then he's applied the old standard method from that point onward. So that is circa 710 dwellings a year. And he's done that in trajectories 1, 2, and 3, all of which result in a shortfall over the plan period. The two where he's applied the higher standard method, i.e. the present standard method, 1481, is trajectories 4 and 5, which do show obviously the more substantial shortfall. So, so yes, I agree. It's not unsurprising that there is a shortfall based on new standard method. My point is, there's an even greater. There was a shortfall anyway.
Yeah. Okay. All right. I hear what you're saying. Now, can I gently lead you back to my question? which is that given, I think you accept, it's wholly unsurprising there's a shortfall, this inspector could properly, as a matter of planning judgment, conclude that the weight he gives to the shortfall as a material consideration should be reduced, given the constraints in this particular borough that have contributed to that shortfall. In other words, as you've helpfully demonstrated, there's lots of highly protected areas.
Yeah.
Which makes it quite hard to deliver standard method, even now or in the past. That's the proposition I'm putting to
Yeah,
you.
no, I don't wholly agree with that proposition.
Okay.
Right. The reason being is that, so you obviously need to look at A, B and C of 190 together. There is a need for the development standard method. That there is a scope, what is the scope for developing outside that designated area or meeting the need in some other way? Well, my answer to the need in another way, housing is housing. It's difficult to do it any differently. But the scope for, clearly the shortfall is relevant, but in deciding how relevant it is, I think you should look at, give weight to the fact that there was a shortfall anyway. Under the old
all right.
figures.
I think that's partly fair. Can I see if I can help move along and get some agreement to this? Look at this in a borough like Waverley, and there are others in this area, but which have got large areas of designated as national landscape or greenbelt. It may just not be possible to meet all of the objectively assessed housing need that one's living. May not be. Right. It's going to be a judgment. There'll be lots of evidence, local plan process. It's likely, in cases like this, that in the future, as part of a local plan process, some kind of planning judgment will have to be made on the weight to be given to housing need, as it may be unrealistic to deliver all of the market or affordable housing need through an emerging local plan. That's a judgment that's going to have to be made. Okay. There is quite a lot of case law on that, which I won't trouble you with, but I will in closings trouble the inspector with it. Okay. But for your purposes, I'm going to suggest this. It's in the context of a Section 78 appeal, what this inspector can't do, faced in this kind of circumstance, is carry out some kind of local plan process. And I'm going to suggest in close the Court of Appeal is quite clear on this, as part of determining the appeal, so as to arrive at some kind of constrained housing requirement figure. And you're not inviting him to do so.
No,
right? And he wouldn't be in a position to do so. Right? But that doesn't mean it's the end of the matter, I'm going to suggest to you, because what I'm suggesting it's open to this inspector to do is not just ask himself, is there a shortfall in housing land supply, which we all agree there is, and we agree is almost inevitable in this district, not going to make the front page. It's whether, in this case, exceptional circumstances have been demonstrated so as to outweigh, so as to demonstrate that the development can go ahead. Now, there will be many aspects to context, but one of them may be the context in which that shortfall he's got should be understood and seen. And if the context is, and I'm suggesting it is, that the district is subject to a considerable amount of protected land, then it may be wholly unsurprising, the inspector may think, and may form a judgment, that there is not a 5-year supply of housing land when you measure that against the objectively assessed policy of need. And that may be a wholly unsurprising thing for him to find here. Do you accept that?
Yes, I do. With a qualification, obviously geography is important, and geography will be important in you coming to a judgment as to the scope for alternatives.
Now, in those circumstances, I think we've got the building blocks pretty much agreed. It would be open as a matter of planning judgment, if I'm troubling you with this, for a decision maker to conclude that some degree of shortfall is inevitable in Waverley, given the position, and that may well affect the weight this inspector gives to any shortfall in his overall consideration, so far as we're concerned, under the umbrella of 190 national considerations. Yeah, okay, that's all I'm saying.
Well, I hope I've answered this already, but perhaps not in the way you wanting, but there was a shortfall anyway, based on the old need.
Yeah.
And indeed, actually, based on the constrained local plan figure, 590.
Mm.
So I've gone through that evidence already.
Yep.
So,
Yep. So it's not a new position. It's wholly
well, it's-
unsurprising
no,
we're here. This has been a constrained borough for, I mean, there's been national landscape here for a while.
Since 1958.
Yeah.
So,
It's not that surprising.
no, so the fact that there is a shortfall, in my planning judgment, is a bad thing. To put it into sort of good or bad language,
Yeah.
something should
Okay.
be done about it to meet the housing needs, which is what national policy is seeking all local authorities to do. And-
So, okay. Sorry, I don't want to cut you off.
No,
now.
no, I think I've finished my point.
Okay, well, I'm really suggesting this inspector should not, in fact, I'm going to invite him not to close his eyes to the existence of the constraints you've been talking about when making a development control decision. Those constraints and the reality of whether that leads to a shortfall or not, I'm going to suggest is highly material to his decision on what weight he gives to any shortfall. That's all. Is that agreed as a?
Well, I think what we could agree in inverted commas is consideration of the shortfall is important, sir.
Well, that's not the same point, actually.
But
We can go there. I mean, I don't particularly want to go there. There's a Court of Appeal case called Hunston. Are you familiar with that one?
Hunston, yes, about 10 years ago, was it?
Probably.
Yeah.
It was the reason I thought you might be familiar because the last inspector grapples with it, doesn't he?
Yes, he does, from memory.
And that in a greenbelt context makes the point, and I'll make submissions on that in closings. But it makes the point that the crucial question for an inspector might not be, is there a shortfall? It might be, what are the reasons for the shortfall? And if it's a particularly constrained area, as it was in Hunston, it may well affect the weight to be attached to any shortfall in reality. Okay, but let's draw it back to your world of policy, because if you take up NID 13.17, which Mr. Marici's very helpfully produced some extracts from the PPG, to save us all trying to find them on the internet. So NID 13.17. Excuse me.
Yes, I've got it.
Now, there are three parts of it here, but if one goes to the third page, this is, in your world, guidance setting out what, in fact, Court of Appeal said in Hunston. So go to the second sentence, which I'm concerned with. So there's a heading: how should development within national parks, the Broads, and area of outstanding natural beauty be approached? So far as it refers to AOBs, it's covering us now.
Yeah.
Second sentence, its policies for protecting these areas may mean that it's talking about the NPPF, may mean that it is not possible to meet objectively assessed needs for development in full through the plan making process, and they are unlikely to be suitable areas for accommodating unmet needs from adjoining non-designated areas. Now, there's two quite important parts to that. I want to take the first one first. That's making the point I've just been going through to you, isn't it? In guidance terms, potentially of as much importance as the NPPF, as we now know, that this inspector is being told by the government, the same government that's urging 1.5 million houses and so forth, it may not be possible to meet objectively assessed needs for development and through the plan making process. And that's may well be the case in Waverley, and that's relevant for this inspector to be aware of and take into account, isn't it?
As context, yes, but with qualification, I think this PPG is directed at plan making rather than decision making. It does refer to plan making in the fourth line.
Look at the heading.
How should development within the national parks
All right.
be approached?
Yeah. I don't think it says plan making, is it?
So
No. It's exactly what we're dealing with.
it's
actually.
it's a second line. It's policies for protecting these areas may not mean that it's not possible to meet the OAN
Yeah.
for development in
Yeah.
full through the plan making
Yeah.
process.
Yeah, because I'll tell you why it's relevant.
Yeah.
You're coming to this inquiry, and I don't blame you for it. I suspect I might have been doing the same. you're saying to the inspector, 1.28 years, objectively assessed need, they're miles off the 5-year land supply. But when you actually understand the context and you actually see the same government that's urging building 1.5 million homes is telling decision makers through its guidance that it's just, but bear in mind, it may not be possible to meet those needs, those objectively assessed needs in areas like this, heavily constrained areas, nationally important landscape to be protected. Just bear that in mind when you're considering what weight to give to these issues. That's the point I'm putting to you. It's material. Because we're a national landscape 190, it would be material in any planning decision. But 190, it finds a home in, including in terms of any national considerations. It's a national consideration. This is a heavily constrained area. That's the point.
So I understand the point. It's more material if we were sat at a local planning examination now and deciding
Yeah.
whether or not the standard method need can be accommodated.
Well,
Is it relevant for a Section 78 appeal? For context, yes.
yeah.
But I've returned to my previous answer. So you've got the evidence. All you've got is the evidence before you in terms of the alternative sites and where the council is with its local plan production, which is at an early stage.
Yeah. And if you're, as you keen and quite correctly keep telling us to bear government policy as a whole and lots of moving parts, towards a danger just to read one bit out of context, isn't it? So when we've got our 1.5 million homes requirement, it's important when we're looking at the specifics of this site to look at the second part of that sentence as well, isn't it? Because this is the government's view. The same government that's saying all the things you rely on is also saying that the national landscapes are unlikely to be suitable areas for accommodating unmet needs from adjoining non-designated areas. Now, if we look at your plan you've helpfully produced, Hazelmere is sort of not entirely surrounded, but quite heavily surrounded by national landscape. Hazelmere is obviously a non-designated area itself, which adjoins a designated, in this case, national landscape area. Yeah.
Well, I think the proposition post the National Landscape Review is for the town to be entirely surrounded by national landscape, with the exception of the southern boundary, which is bordered by the South Downs National Park.
Well, okay, and I'm just dealing with now. I mean, that may well be the case, and if that's justified in evidence, then great. But let's just deal with the point I'm putting to you now. I think you know what it is. That again, this is relevant, isn't it? That it's not determinative, but it's an indication of how, when you read policy as a whole in context, and then you turn your mind to whether there are exceptional circumstances. And the fact is, the government is pretty clear where it wants housing to go, how it wants housing to go, and it's pretty clear on what it thinks about whether areas such as you're proposing are likely to be suitable areas for accommodating unmet needs from places like Hazelmere. And the government's policy is it's unlikely to be suitable. That's what they're telling the inspector.
Sorry, Mr. Scott, you might need to clarify the questions. Unmet needs from Hazelmere. Isn't a paragraph in the PPG referring to unmet needs from other local authorities?
Well, have a look what it says. I mean, you tell me. You're the planner. I'm a mere lawyer. So it's your expert in evidence, not mine.
This is
unmet needs from adjoining non-designated areas.
Yeah. So I mean, I read that because I read this. And this might be a point of disagreement. I read this PPG paragraph as more to do with plan making and making a decision on the soundness of a local plan. I think what it's saying is that if you're a District A with no national landscape and you happen to be next door to District B with lots of national landscape, District B shouldn't be taking the unmet needs from District A.
Yes, I don't think you're right. But and I say, and I'll suggest why it's because this is dealing with national parks rather than districts, you see. It's
National
dealing with
parks,
development
not
within,
yeah.
national parks and national landscape.
AOBs, yeah.
It's dealing with designations rather than district areas.
Yeah.
And in the particular sentence we're looking at, it's saying those areas, not districts, they are unlikely to be suitable areas for accommodating unmet needs from adjoining non-designated areas, not districts. I mean, it may well be it's another district, it may not be, for all I know. It could be in the middle of a large district that has non-designated areas within it, but that's the purpose of this bit of the guidance. There are other areas of housing which do refer to areas in the sense you want this to read. But anyway, maybe that's an issue between us, make submissions on it.
Yeah.
Really what I'm putting to you is that it's when you look at those bits I've taken to you, there's a clear indication, again, that the government is not, is putting some pretty large warning flags for proposals in national landscapes for present purposes, in terms of objectively assessed needs and in terms of trying to meet needs from adjoining areas.
I mean, that is essentially why the exceptional circumstances test in paragraph 190 exists. It's a high bar.
Yeah, but it doesn't exist in isolation.
No.
You've
No,
got to,
you
you've
read
got to
the
understand
NPPF
the
as a whole,
context around it. Grey belt, brownfield, paragraphs like that, not just 1.28 years land supply. That's my point.
Yeah, but planning judgment needs to consider all the evidence in the round. and
Yeah,
decide-
good. Well, where have you considered that in your proof, that paragraph?
What, with the PPG?
Hmm.
Well, I've taken the view that that is more to do with plan making than decision taking.
Well, even if it is, it's still relevant, isn't it?
So, but the context.
I mean, shall I help you? Let's go to your proof at 433. Because you do refer to that paragraph, in fairness to you, but you just don't refer to those bits, as I recall, but I may be wrong. 4.33 on page 45.
Yeah.
You say the PPG recognises that, quote, the scale and extent of development to national landscape should be limited.
Yeah.
It recognises that development will, quote, need to be located and designed in a way that reflects their status as landscape's highest quality. Then you give the paragraph reference, which is this paragraph, but
Yeah.
what you have done, and I'm not suggesting you did it deliberately for whatever reason, but you've missed out the bits I've taken you to, haven't you, which Mr. Johnson's referred to,
So,
and which the
and-
previous inspector relied on as well.
yeah, well,
Decision.
I mean, it's a point of disagreement. I've just interpreted those points you've taken me to be to do with local
know.
plan making because of the reference to plan making in the PPG.
Wouldn't it be good to have it in your proof, do you think, just to grapple with it? I mean, they're clearly relevant, aren't they? Well, quite important issues for the context of what we're talking about.
I chose to focus on the other bits because I thought those are more relevant for decision taking.
Right.
Because we're a Section 78 appeal, not a local planning examination.
Okay. Well, of course, decisions about where and how to deliver any adopted requirements are fundamentally aspects of plan making rather than decision making. Okay, all right. Okay. Let's see if I can cut out some questions to make everyone happy. There's some other ministerial statements which say much the same thing. I'm going to save time and I'll just deal with them in submissions rather than go through all of them to you. There are some other ones, but I think if that's, we've looked at 125. Now, turning to policy relating specifically to national landscapes. Now, we're all agreed it remains, I'll put it slightly emotionally, but as strong as ever in 190 in terms of its protection of national landscapes with a very high hurdle.
But yeah, it remains as it has done for 15 years.
And when we look at the government policy in the round, and we've looked at some aspects of it, context of how it wants to be delivered, in truth, the new NPPF provides absolutely no support for any greater development in the national landscape than previously was the case.
It remains the same.
Well,
Yeah.
I'm going to suggest it's worse. It's harder given the context, but as a point of agreement between us, can we agree there's no greater support for development in the national landscapes than there was before December
Well, I
2024?
suppose that's one way of putting it. Remains the same. There's no
Fine.
greater
Well,
support.
the Labour government could have said, look, we've got a housing crisis. We need to deliver houses. We're gonna loosen the national landscape test a little bit. We've done it with Greenbelt. We're going to do it with national because it's a national. They haven't done that. It remains as strong as it ever did in terms of national landscapes, the policy protection.
Yeah.
Unlike Greenbelt, unlike Brownfield, which have changed. Okay, fine.
That's fine. I've accept that.
And they've clearly identified routes to deliver housing, local plans, brownfield, grey belt, we discussed. And so understood in that context, in terms of policy considerations and national considerations, national landscapes remain areas to be, in policy terms, cherished and protected.
Yes.
Yeah. Okay. Now, okay. Now, in terms of the approach you dealt with in your evidence in chief, the approach to 190, the overall question asked of, in this case, the inspector, as to whether there are exceptional circumstances or not, is, I suppose, a classic test or classic exercise of planning judgment, isn't it, in the end of the day?
Applying 190 is planning judgment, yes.
Well, I mean,
Sorry.
keeps you in a job, but I think that's what it is. It's a planning judgment.
Well, the day the High Court starts intervening with planning judgment, we're all out of a job. Yes. So it'll also clog up the system.
Well,
as well. But yes. In short,
Okay, all right. So it's a classic planning judgment. And the reason I say that is, and the courts have dealt with this fairly recently, when one looks at 190 and then sees A, B, and C, they're not a series of tests. But sometimes you get in policy where you have to tick or pass each one. That's not the way 190 is to be applied, is it?
Well, you need to undertake it in the round A, B, and C. So
You need to consider those matters, not limited to those matters. You can consider other matters if you like.
Yeah. So
but I mean, look, to help you, you could in theory, here's one for you against me. You could in theory have some degree of detrimental effect on the environment under C, and still there might still be an exceptional circumstances case in a given.
well,
Might be.
Yeah, it's not as simple as
No,
pass or
so it's
fail.
not a part.
At
It's not
each
a
of
sort
A,
of
B, and C.
exactly. That's what I'm saying.
It's an in the round judgment.
It's very much a judgment. Okay, and but the starting point, of course, when you're dealing with 190, is that you've got a nationally designated landscape with the highest status of and level of protection in national policy. This is the equivalent of a national park in terms of levels of protection, isn't it?
Well, I suppose the only difference is that a national park is its own authority and has its own differing objectives. So,
But that doesn't change the policy test.
but
Does it?
the policy test of 190 affects parks, broads, and national landscapes.
Right.
So, in that regard, yes.
So would it be fair, as a matter of planning judgment, it would be appropriate for it to be applied in the context of major development of 190 in a fairly stringent and robust way, given the nature of what's to be protected?
Well, yeah, it's an exceptional circumstance. So,
Okay. Now, management plan, core document 7.9, we can by all means go to it if you like. It may be useful just to quickly turn it up, I suppose. Do you have it?
yeah, it's just my computer is getting there.
No, I'm not there either. I'm just hoping I'm not too far behind. Right.
Yeah,
Okay.
which page?
Well, we'll go to page 32, PDF 17, hard copy 32.
Yeah, 17. Yeah.
So we're about the last people to get to look at this together, Mr. Collins. It's been looked at by the inquiry many times, but it's obviously as a document as a whole, it's a material planning consideration, deserving substantial weight.
Yeah, I think in this particular case, because it's developments in the A and B.
And we know that the page 30, PDF 17 on the sort of left-hand side, prime purpose of the national landscape that we're concerned with is to conserve and enhance the natural and scenic beauty of the landscape.
Yeah.
And various points, again, I'll take it quickly, but various points are made in the text there, broadly saying, it's subject to a significant pressure to development due to to the economic success of London and the South East, and combined with the very attractive environment of the Surrey Hills. That's sort of one of the sort of contextual matters the management board, the management
Yeah.
plan makes. Now, within the document on this page, there were two policies that the council, through Mr. Johnson, pray and aid. So for members of the public, not development plan policies which are a material consideration. P1 and P2. Now, there's an issue between us. We say there's conflict with both P1 and P2. You say, I think that there's, yeah, so well, in the Germans and Chiefs, so as far as P1 is concerned, as I understand your evidence, you say it's complied with because there are exceptional circumstances made out.
Yes, that's correct.
Yeah, I heard that. Like, it's a sort of slightly circular argument, isn't it? Because you could I put this to you that, you know, on the road, on the journey to deciding whether there are exceptional circumstances or not, one of the things you might look at is, for example, the management plan, and ask yourself whether the particular proposal conflicts or doesn't conflict with relevant policies in it, and that might provide you an answer as part of a piece as to whether there are exceptional circumstances or not. So you're sort of having a sort of chicken and egg thing, isn't it? You're saying, well, because there are exceptional circumstances, therefore there's no conflict with P1. Haven't you got to grapple with what P1 says and come to a view?
Well, I mean, in terms of what P1, I mean, obviously in determining whether or not there's exceptional circumstances, 190C is relevant, which is the effects on the environment and landscape.
Yeah.
So I agree and accept that great weight needs to be given to any harms as per P1 and also the NPPF itself. But likewise, that should apply to any benefits and enhancements to the landscape. So there is an adverse impact on
Right.
LCA 1 and 2, not repeating the landscape evidence, that's all been done, but that's what was said by both
Right.
witnesses. But the inspector will need to judge the proposal as a whole,
course.
and therefore give great weight to the various measures in the 78% of the site, which is retained and enhanced green
Yeah.
infrastructure.
I won't forget. I promise I will come back to this. But can we just look at the wording of P1 then? Because if we're going to, you know, make progress on when it looks at that, it says balancing different considerations. Great weight will be attached to any adverse impact that the development proposal would have on the amenity, landscape, and scenic beauty. Right. Yeah. Now, so to some extent, you accept, like I think you're referring to LCA 1 and 2, there will be adverse impacts. The detail and debate as to others.
As a point of principle, yes.
Yeah, but even on your case, I mean, there's a vast difference in terms of the findings of others. But even on your own case, you accept there's a degree of adverse impact. So to that extent, there's an issue there with P1, isn't there? In the sense that these are not statutes or contracts. You've got to apply these with common sense, these kind of policies. But you've got a situation here to some extent. There's going to be an adverse impact on the landscaping, scenic beauty of part of the national landscape, isn't there? Because of this development. That's just inevitable.
In that part of the site,
Yeah.
yes.
And so to that extent, and I hear what you say about the inspector's got to look at it in the round, but there's going to be some conflict with the terms of P1 as written.
On that first half of it.
Yeah.
But the last few lines say, and the need for its enhancement.
Yeah, sure.
And the proposal enhances the AONB, sorry, the national landscape and the balance of the site area.
Yes,
So-
you're talking about the landscape improvements and the
Woodland
open
management,
space.
landscape improvements,
Yeah.
SANG.
Yeah, but I mean, again, I don't want to go, but you know, that's how they're given. We see what weight Mr. Smith gives them, either slight to moderate, and I mean, I've been through him what that means in his terms, and I'll make submissions on that. But I mean, on the 5 hectares, 22% of the site, as you've drawn the site, I mean, you could have drawn the site a lot smaller, a lot larger, but there's 5 hectares of area which are going to cause degrees of adverse harm to the national landscape, right? And to that extent, there's going to be an issue with P1, if I put it as neutrally as I can.
Well, yes, on that
Yeah,
part of P1
Yeah, okay.
and that
Now-
part of the site.
And the same would apply, the same logic would apply therefore to P2, because to that extent at least, the proposal is not going to respect the special landscape character of the locality, is it? Because it's going to harm it to that extent.
Well, that, for that part and
Yeah.
that part of P2.
Yeah.
Correct.
Now, the people who, and I don't, people who know about these things, if I can put it that way, the management board, those who draft this document and who are experienced in providing consultations have obviously objected to this proposal in fairly strenuous terms, haven't they?
Mr. Clive Smith and then the, yes.
Yeah, yeah, and there were several responses. And I think it was, but I mean, in fairness, certainly the chair has directly given her view, we can go to it if we need to, on these policies, hasn't she, in her representation in response to the inspector?
I recall that, yes.
Yeah. I mean, we can go to it if you want, but she reports, she thinks there's a conflict with P1 and P2.
P1 and P2.
Yeah.
Yeah, that's, I mean, I've responded in my rebuttal to Mr. Clive Smith.
Hmm.
Section 3. I think I dealt with the chair. I'm sorry, I don't.
Well,
know
don't
how
worry.
I-
No, you probably
Sorry.
have, but I just wanted to put that to you that I mean, I'm going to obviously submit to the inspector that that's of some importance in terms of when you've got actually the chair of the board, or Mr. Smith, people who are in a sense custodians of the national landscape, writing to the Secretary of State through the inspector and saying, actually, look, we think there is conflict with P1 and P2. That's of considerable importance, isn't it?
Well, it's certainly relevant. The reason, I mean, I obviously do quite a few schemes in Surrey. I mean,
Yeah.
With all due respect to Mr. Smith, as in Mr. Clive Smith, he objects to everything. So
Right.
I don't think there's much.
Well, I don't know. I haven't got all.
No, I know,
I haven't
and
got all
that
those
evidence is not
responses
before us
to-
in
so I
court, which I
can't-
fully
don't,
accept.
you know,
But I mean,
just deal with what he's done now and look at that. But let's make it easy for you. Let's just talk about the chair of the board then. I mean, she's taken the trouble to write in. The inspector's read it, and we can go to it if you want. But she's pretty clear on her analysis of the harm and the conflict with these policies, isn't she?
yeah, so it's Catherine Atkinson, isn't it?
Yes.
Yeah. So I've responded to that, sir, at paragraph 1217 of my main proof. So I accept she's objected, and I accept that needs to be given weight, whether or not the degree of weight goes to the heart of whether or not she has made any cogent submissions of evidence. I would advise you, sir, to have the greater regard to the specific landscape evidence discussed at this inquiry, because I do view their general position as just being an objection of principle.
Well, I mean, to be fair, Mr. Collins, you very fairly have accepted. You can see why there might be issues with parts of P1 and P2, having looked at the actual wording of it, so far as LCA 1 and LCA 2 are concerned, haven't you? In answers a moment ago.
Yeah, part of the policy on part of the site.
Yeah.
Obviously, all of the policy on all of the site is probably the best way to approach it.
Oh, okay. All right. So anyway, okay. So you don't think they should be given particular weight? In the
No, they should be given weight. I'm not saying ignore them. Whether or not the degree of weight, I think, goes to the heart of what they're actually saying.
Yeah,
and
but
the submitting.
Your contention. I mean, I'm going to suggest, and because you raised the issue, that they have turned their mind to this proposal. I mean, you keep saying there's an in-principle objection. Are you suggesting that they didn't even really look at the scheme? They just said, right, it's in the national landscape, we're going to object. I mean, I would suggest you, when you look at those responses, the authors have taken time to consider what's been proposed, and they've turned their mind to it and reported to the inspector what their belief is, not just in principle.
Yeah, so, I mean, that's my opinion, obviously, but if it were, I would have hoped for a more balanced opinion from Catherine Atkinson as the chair, because the proposal actually, as we outline it in our evidence in our case, actually conforms and complies with a number of the management plan policies to enhance and manage a significant part of the site.
Yes. Well,
And
maybe,
so it would have been, I think, more balanced for her to have at least acknowledged that. And she still could have come against the scheme on balance, but that wasn't the case for her.
okay. Now, sorry, I don't want to cut you off.
No,
but-
it's fine. Well,
but-
the only other thing I was going to say, I was expecting Mr. Clive Smith to come to the inquiry and provide his evidence already, but it did surprise me that he didn't come. He was at the phase 1 inquiry.
Well, I don't know why, so
So
I
it's
can't
just-
help
it
you, and
just-
not sure it's helpful to speculate. Right, now, so far as the other matter, contextual matter, the statutory duty, we've got as we all know, amended section 85 duty, which now requires, in this case, the inspector to seek to further the purpose of conserving and enhancing the natural beauty of this national landscape.
Yeah.
And I'll try and take this as fully as we can because it's partly matters of law, but a little bit of guidance and planning as well. We've got the DEFRA guidance, which you referred to in evidence in chief. That wasn't available to the last inspector, I think, was it?
No, it's more recent.
Again, perhaps I can deal with the submissions, but it clearly bites here and something this inspector will have to consider and do his best to comply with.
I think it's, yeah, it should be considered.
And again, there's a fairly recent case, which I think has gone in, the New Forest case. Yes, it has, thank you. And which has clarified that if clarification were needed, but perhaps it was because there was a debate before the judge, that the seek to further duty is a strengthened duty from that which previously existed a couple of years ago. Yeah.
In broad terms, that summary is yes.
Yeah, I
Correct.
mean, I'm sparing you the pain of going through Mr. Justice Mould's judgment and sparing the inspector the pain, so that we won't finish this afternoon, but
No,
I'm
that's
happy to.
fine. I'm sure,
you
I'd
want
be
me
quite
to.
happy for you all to leave it for legal submissions, to be fair.
Yes, well, I'm trying my best, to, but,
If that helps you, sir.
okay. Anyway, put it this way, it adds to matters which may, I'll put it as neutrally as I can, may again weigh against the proposal in a material way if the inspector accepts some of the evidence of the local authority and feels that this is not a proposal that's easily going to seek to further the purpose of conserving and enhancing the natural beauty of the area. It's a consideration, more than that, it's a statutory duty. Inspector's got to grapple with.
I think, sir, you clearly need to have a section in your report on this
Yeah.
because it's part of the decision-making process. I think my simple planning points would be national policy, as in planning policy, is still the same as it was. So obviously the government's felt it doesn't have to update the NPPF. And obviously the duty is to seek to further. It's not to further. And there's a distinction there, something which you'll no doubt have to grapple with in making your decision.
Yes, no, that's fair,
Yeah.
but it's more than just weighing it in the balance, isn't it? From when you write your proof, as all good planners, you're trying to invite the inspector to do what you're doing in your judgment and your balance. But it's not just a question of saying, oh, there's the duty, I better weigh that in. It's more than that now, isn't it? It invests the decision maker with the responsibility to judge whether what's before him does in fact interfere with the fulfilment of those purposes, and if it does, why the grant of permission is justified.
Yeah.
It's not just a sort of I'll stick it in the planning balance and take it into account job. It's a lot more exercising than that,
Yeah,
I'm afraid,
as
isn't it?
On that proposition, then yes,
Yeah.
it's a legal requirement, isn't it?
Now, how have you, I mean, have you done that in your evidence? Is really my question. Where have you set out the approach to how you've weighed the statutory duty? I'm sure you have, and I'm sure you're going to tell me. But I just want to understand, so for my note, where exactly you grapple with that.
The first bit of so section 4.24
Yes.
I'll go through, I introduced the LURA.
Yeah.
Which obviously led to the amendment of section 85 and I introduced the DEFRA guidance.
Yes.
And then, I mean, in terms of my approach of the overall weighting to the harms and benefits of the planning balance, I've had regard to the harms in part of the site and the enhancements in the larger part of the site. So that's towards the end of my proofs. That's section 14 and 15.
Okay, good. Thank you. Now, again, the last inspector didn't actually have the benefit of the guidance, but the last inquiry came to the view that there would be conflict with the expectations of the amended section 85, didn't he? The inspector's note, that's AD appeal decision para 179, which we were familiar with, but it's just a matter of fact, that's what the last inspector found. Is that right?
As a matter of fact, then, yes.
As a matter of judgment
Yeah.
and applying the, I don't think you're suggesting he applied that statutory test incorrectly, are you? It's his judgment he formed.
That's his judgment.
Yeah.
Yes.
Right. Now, nearly through context, we do also have another, go back to NID 13.17. The government chose to add some more guidance in their provision of lots of new context for us to grapple with in January, just a few weeks ago, didn't they? And that's the first page of 13.17. No, it's not. It's the second page of 13.17, NID 13.17.
So this was updated in January.
29th of January.
Yeah.
Excuse me. Under the heading, what are the statutory duties of local planning authorities in relation to national parks and so forth, for which one could interpose inspectors, I suppose, the decision maker. Yeah. And referencing the changes. And now it took the trouble, didn't it, in the guidance in the second sort of substantive paragraph to emphasise this duty is particularly important to the delivery of the statutory purposes of protected landscapes. So the government has chosen, hasn't it, through the PPG to emphasise to present purposes this inspector the importance to the delivery of the statutory purposes that the duty plays in decision making. Yeah.
Yes.
And again, as part of the context of how one considers whether this is an exceptional case or not, that is highly relevant, isn't it? That the government's chosen to include that as part of its, as you say, everything's got to be read together, policy guidance context.
The government is encouraging decision makers, well, I suppose the policy and the law is requiring them to have regard to the duty in making their decisions. Yeah.
Okay, good. Right, thank you. Now, moving on to the next topic, I think you fairly accepted in your evidence in chief, there's quite a lot of, well, there's a vast difference between us, frankly, on some of the evidence on landscape, particularly landscape character, which, although I have lots of notes to go through the differences with you, I'm going to resist that because I think
Probably be a waste of time.
well, I know, you never know. But I think it would be test everyone's patience and mine. And we're both, Mr. Marici and I keep threatening to do bigger and bigger tables in our closings to set all these differences out. So the inspector's going to have all that in due course. But really the point for the debate with you is to just identify there are some quite significant differences in terms of the findings. And obviously you've taken the findings from Mr. Smith and put them into your overall balance.
Yeah.
The council's taken findings from Mr. Petro and indeed others. But that will have those different inputs, if I can put it that way, are bound to have a material difference in the outcome of the planning balance in this case, given the importance of the subject matter we're dealing with.
Well, I think it's fair to say that both myself and Mr. Johnson recognise sort of two broad harms. One is landscape, the other is trees.
Yeah.
at this point.
No, I get, absolutely. And but I'm really, what I'm saying to you
So
is,
the weighting you give to the harm
yeah,
would differ dependent on whether you prefer
Yeah.
Mr. Petro's evidence or Mr. Smith's.
of course it does.
Yeah.
Or, yeah, or others, but yes, fair. And, when one's looking at the list of factors one considers under 190 and elsewhere in policy in terms of landscape harm and so forth, but particularly in 190, because we're talking about a national landscape, because of the context we've been through, of how important it is to preserve their natural beauty and so forth, findings on that particular topic matter are obviously going to be key to the ultimate conclusion on exceptional circumstances, aren't they?
Yes.
And so, to be brutal, and you don't have to answer if you don't want to, but I suspect if you were inputting some of the findings of a much higher degree of harm at the residual end to landscape character, you would have been coming to a different overall conclusion in your 190 than had you relied on the evidence of Mr. Smith.
Well, I mean, overall, I've come to the judgment that there's a moderate landscape harm, as you can see from my proof and rebuttal.
Yeah, no, I know.
So, based on my scale, you could increase it to significant if you prefer the evidence of Mr. Petro, potentially. But that's one factor. There's one factor that goes into the 190 planning judgment.
I understand that. And I'm not asking you to, I'm not going to say I've got you. I'm just trying to understand how you've come to your overall judgment, you see, to Assistant Inspector, because put it this way, the last inspector came to, put it in more layman's terms that I will understand, he came to an overall conclusion, lies the evidence that there was fundamental and serious harm to the landscape presented to him in relation to the appeals. That's his findings, and you obviously you strenuously disagree with that. If you had that evidence if you were of the view that there's very fundamental and serious harm to this national landscape, you wouldn't be recommending approval of the scheme, would you?
Well,
and that's because of the nature of the.
It's less likely, yes.
Yeah. Well,
So, I mean, because the reason why I don't say a straight yes, no to that is clearly you've got to look at the other parts of 190.
Yeah.
We're focusing on 190C at the moment. We're talking about
I know. But I'm suggesting to you that when you understand the context of how important national landscapes are, as we've been through, statutory protection, government's emphasised their critical, new PPG in January emphasising it. If a decision maker is faced with a scenario where there's serious and fundamental harm to the national landscape, you input in then your planning balance, take out what you put in at the moment. You would, I mean, frankly, any decent planner would be recommending refusal in light of there wouldn't be exceptional circumstances. That's fair, isn't it?
I mean, it would be a highly relevant consideration, which you'd give great weight to.
Well, that's not answering my question. I mean, I don't know. I mean, it's quite an easy question.
So, I mean, I suppose you referred to the previous inspector's decision on this matter. I mean, I don't agree with that bit of his decision. In the hypothetical scenario.
Hypothetical.
Yeah.
I'm not suggesting, Mr.
Yeah.
Collins, you think,
So,
but I'm putting to you the views of others. I think it's unfair to me.
But clearly, if there, I mean, it's your case, obviously. If the detrimental effect on landscape is judged to be that strong and severe, you give great weight to it, and that weighs against the scheme overall. So, which.
And I'm suggesting in that event, in this case, in fairness, your duty to the inquiry would be recommending that there wouldn't be exceptional circumstances in that event. That's not your case, but that would be the situation in fairness, wouldn't it?
I mean, to answer that directly, probably. The reason why I don't give it a yes, no is because you've got to still consider A and B, so the severity of the need, et cetera, et cetera. But
well, I know that, but when you say probably, you have considered A and B in fairness. I'm not asking you to. I'm asking you to do it with that one different input. And in fairness, I mean, frankly, I didn't think it was a difficult one, but I'll take probably. You would be saying there wouldn't be exceptional circumstances. I'm going to suggest. I mean, almost certainly it would be, because if you're faced with fundamental and serious harm to a national landscape, it's not going to be exceptional, is it?
Hypothetically, yes, but
right.
Just
okay.
For the notes,
I'll take that.
I do disagree with the previous inspector's conclusion.
I know you do. I know you do. But you see, hypothetically, yes, I'll take that because and the reason I'm putting you through, you maybe think I'm being unfair. I'm just trying to understand where things lie in the overall judgment, because, you know, you could have said to the inspector, and I would have suggested you a role, and I think you're right not to have said it. Well, the housing need is so great and vast at 1.28 that even with serious and fundamental harm to the national landscape, it would still be an exceptional circumstances. But in fairness to you, you haven't said that, and frankly, quite properly. And you've accepted, you know, that if the kind of harm the inspector found at the last inquiry is found by this inspector, you'd be saying, yes, no exceptional circumstances. Fair?
So I take the point.
All right, that's helpful. Thank you very much. Excuse me. Now, when I look at some development plan policies with you, the SP2, again, however you want to go to these, I mean, you have helpfully, I thought was a very clever way of doing it in the learning friend took you through the planning statement of common ground, which usually summarises them. So we can do it that way. If at any stage we want to go into the wording of the particular policy, let's do that. But they tend to make my computer crash whenever I get one of those last documents out. But can we just look at, I'm looking at LPP1 policy SP2. If you want to go to the policy, it's in core document 6.1 PDF 20.
Just get it up.
So whatever suits you.
So spatial strategy SP2.
Yeah, SP2, and that, and you also obviously you've got your table in your proof, page 26, haven't you?
Yeah.
As amended by your rebuttal in some regards, where you set out your view on each of the various policies. So however you want to do that. Now, some of the approaches you take to policy are sort of follow a similar logic, so I can perhaps grapple with some of the points as we go along. But are you at SP2?
Yeah, so I'm at SP2 and
Yeah.
a number of pages. I'm just,
Okay, right.
uh,
So that policy, as we've all seen, sets out, doesn't it? I think it's 8 high-level criteria guiding distribution of development spatial policy. You say it's out of date, and you're right in the sense of it being, in terms of the trigger in 11D, it's out of date.
yeah.
But maybe the issue between us is the weight to be given to it as a policy, notwithstanding it's out of date. Yeah. Now, can we just agree, as with all policies, not all bits of it are going to be relevant to any given case. The key part I would suggest to you, so far as we're concerned, is point 1, isn't it? In other words, avoid major development on land of the highest amenity and landscape value, such as the AONB, and to safeguard the green belt. And I know you say there's a reference to at development as well, but
Yeah.
that part I've just read to you, part 1, is plainly consistent with, well, the Section 85 statutory duty we've looked at, isn't it, to avoid major development, yeah?
Yeah.
Also would be consistent with the thrust of para 190 of the MPPF.
The thrust of, yes.
Well, I mean, 190 is seeking to avoid development in the national landscapes, isn't it, frankly? And you can have it, but only in exceptional circumstances. So the thrust of it is no.
Yeah.
Yeah. So in that sense, it's consistent. Not in dispute, obviously, that this is a major development. And it would also be consistent with that latest little update in January of the PPG we looked at, which emphasises the importance of delivering the statutory purposes of national landscapes. Yeah, so it's consistent with all that. Would also be consistent with some of those aspects of the PPG that we've looked at addressing housing requirements, which note in particular that designations such as national landscape may mean it's not possible to meet objectively assessed needs for development. It would be consistent with that as well, wouldn't it? Okay, now, because of that level of consistency, I would suggest to you that that policy is in fact, when understood in context, deserving of full weight, despite being out of date.
Well, I mean, the policy is a visionary policy, essentially, isn't it? It's supports the overall spatial vision. Maybe point 1, take all those points consistent with paragraph 190. which is ultimately permitting major development in exceptional circumstances. I mean, I've given this policy, I've recorded, I've stated it's out of date, but I think this policy should have a fair degree of weight. Probably not full weight, because the plan in itself is out of date, as I've said in evidence in chief.
Yeah, okay.
And so I'm not suggesting this policy has no weight. I'm just inviting the inspector to consider it's out of date and should be given some weight.
I've recorded a fair degree of weight. Would that be?
Yeah.
So I think
Yes.
it's what you said a moment ago. I mean,
Yeah, and I think the proposal
use your scale.
moderate.
You're hoping for a bit more. But
Yeah, so let me just finish. Obviously, criterion 1 could still be complied with on the basis of triggering exceptional circumstances. I think that would be consistent. I think Mr. Johnson and I actually both agree that this proposal is at Hazelmere. That's the wording used in criterion 2. But then, not every criterion in this policy is relevant to this proposal. So other aspects refer to other settlements, 3 and 4. And indeed, to be fair, it's probably the rest of the policy isn't actually directly relevant at all.
No.
Apart from 8, because the development will provide seal and provide infrastructure.
Yeah, it's the same theme we grappled with before to some extent, Mr. Collins, isn't it? This proposition that you find compliance with the policy on the basis that further down the line there's a conclusion of exceptional circumstances. When I first heard that, again, it did strike me as a rather chicken and egg position, because haven't you got to just, first of all, the inspector's got to look at the wording of that, apply it the common sense way, and find whether there's any conflict with relevant parts of it. We're agreed a relevant part of it is point 1.
Yep.
I think we're agreed that that's deserving of a fair degree of weight. I'm saying full weight because of its consistency. And in the sense, and so far as it takes it anywhere, this obviously your proposal is not seeking to avoid major development on land of the highest amenity value. It's doing quite the opposite. And to that extent, it could be said there's a conflict with the spatial strategy. That doesn't mean at the end of the day you couldn't comply with the development plan as a whole. Of course you could, but as a matter of fact, applying that in a common sense way, there's a conflict with the spatial strategy.
On point 1.
Yeah.
But then you judge point 1 on the basis that, I mean, if it was entirely up to date, it would say accepted exceptional circumstances at the end. Sorry, let me just finish and you can come back.
No, quite right.
The final point is Greenbelt. I mean, obviously the spatial strategy at the moment, according to this policy, is to safeguard the Greenbelt. But we spoke about that an hour and a half ago, didn't we? In terms of the fact that in places the Greenbelt is to be softened with grey belt.
Well, exactly.
So
absolutely right.
Yeah.
And that's why you've got to apply the policy. So we're inviting the inspector to look at this policy, the common sense view, in the context of our scheme, which is in the national landscape, not a Greenbelt case. So we don't worry about the Greenbelt here. It may be in a Greenbelt case you'd give that policy less weight, right? But we know that we've been through it, the national up-to-date government position is to give as much protection as ever to national landscapes, right? So now 2, you say again, a point you've made a number of policies. Well, this proposal it's not in Hazelmere, is it? It's adjacent to Hazelmere. It's in the national landscape adjoining Hazelmere. It's not, I mean, clearly if one's looking at what this policy is not requiring the reader not inviting the reader to say, well, don't worry, if you're at Hazelmere, you can focus development there, even if it's in the national landscape. It's not saying that. It would make a nonsense of the policy. So
I've always grappled with this wording, because for some reason it doesn't say in. So if it said focus development in the 4 main settlements, I could understand it. My view is it was written on the basis that the council accepted when LPP1 was drafted, there would be some greenfield development alongside brownfield. So it's and I think that's the reason why it's worded that way.
All right, but even on that, even if you're right on that, I don't think you are. Reading them together, it's clear the policy is seeking to avoid development on national landscape, isn't it?
I accept.
Whether
that-
you're at Hazelmere or in Hazelmere
I
or
accept
by
it's
Hazelmere.
not the first choice of LPP.
All right, good, okay. Now, RE3, while we're in, which is PDF page 64. Again, we visited this several times. So sorry, just let me get there, yeah. Now, again, the stem of the policy before one gets into the part, new development must respect and where appropriate enhance the distinctive character of the landscape which is located. And then point one is really the one relevant to us, isn't it? Because it's dealing with the national landscape. Yep.
Yeah.
And the issue then is whether this scheme protects and enhances.
Mhm.
We're not worried about the setting purposes of this scheme, the second part. So again, let me put it to you this way, to the extent that you've fairly accepted, and as I say, wherever you go in the evidence, that there's an adverse impact so far as LCA 1 and 2 are concerned. To that extent, that part of the national landscape being harmed, there's going to be a conflict with 1, isn't there, in RE3?
Well, if you're just looking at LCA 1 and 2, yes, but we're inviting the inspector to judge the proposal as a whole.
Yeah, but okay. I mean, look, plenty of people have looked at that. The last inspector, they've taken into account the enhancements elsewhere, and they've still said, frankly, there's still harm to the LCA 1 and 2. I mean, that's, I know, and I, you know, I'm not sure you're looking at Mr. Smith's level of benefit he gives them, but we'll make submissions on that. But you're saying, your case, as you see the evidence, is that there's harm to LCA 1 and 2, but because of the enhancements elsewhere, that outweighs any harm. That's what you're saying. All right. Okay, but that's an issue perhaps for others' evidence, isn't it, in terms of
Mostly landscape evidence.
yes. But let's say that again, then I'll put it this way: if there is found to be by the inspector a degree of harm, that clearly there will be conflict with the policy.
Well, the policy refers to national plan policies together with the Surrey Hills AONB management plan.
Yeah.
So this is how I've approached it.
Yeah.
National plan policies means paragraph 190, essentially, in this
Right.
case. And we've gone through the management plan. The case of the appellant is compliance with it. So,
Well, but look at the stem. You've got to read it. You've got to respect and where appropriate enhance the distinctive character of the landscape. If the inspectors, contrary to your view, of the view that there's a degree of harm, I won't even say as high as serious and fundamental as the last inspector, but a degree of adverse harm to the landscape, there's going to be conflict with this policy, right?
if he considers that overall, based on the overall.
Right, fine, yeah. So it's not, again, I don't understand the logic. Maybe I do, because you say, and your answer to this in your thing is, well, if we can show exceptional circumstances, we overcome that. You're assuming in finding exceptional circumstances, there's no harm. That's what you've done to get to that logical position.
Well, in finding exceptional circumstances, you may well have found harm.
Exactly.
It's an overall balance, isn't it? In
Yes,
terms of
that's my
A, B,
point.
and C.
That's my point. So I agree. So, but how do you say then? Well, I've complied with RE3 because we find exceptional circumstances. That logic doesn't work in light of your previous answer.
I mean, the reason why I've done that, so, is because RE3 refers to the application of
Right,
national
I see.
plan policies
Okay.
on the third line down.
Okay. Anyway, in terms of that policy, again, can we just broadly consistent with 190, with the PPG, with the Section 85 duty that we've been through before?
So I don't think RE3 is inconsistent with the NPPF.
No.
So
Full weight, out of date, but full weight.
out of date and hang on a minute. Probably. Let me just have a quick
Check the table.
I
Before you answer the nasty bastard, check the table. Yeah.
mean, yes, it should have weight.
Okay, you said reduce weight in your proof. It's fine, to be fair to you, before you
No, I'm just working out why I said that. It should have full weight,
all right, that's very fair, thank you.
because of its consistency.
Thank you. All right. We'll come back to a couple of other policies a bit later. Now, again, I think I can get rid of some questions. Previous inspector's decision, just a few questions on that, if I may. We've touched on it tangentially on a couple of occasions. Now, the decision, again, with the caveats I said at the outset, I understand you don't think it's material, but so just to assume the inspector is to some extent considering it's capable of being a material consideration. It's still less than a year old.
Yes.
It was quashed. We looked at some of the documents. We'll just have a look at some of the other ones now. It was quashed solely on the basis of what was called ground 2 of the claim. If we go to the NID documents, just to cover a few factual points off, please. So first of all, can we go to NID 1.1? That's the consent order. You have that?
Yeah, I'm just getting up now, so, Mr. Cosgrove. Yeah.
And again, we expect to have seen a few of these with early witnesses, so I'll take it fairly quickly, but that's the consent order with a sort of logic, excuse me, and the schedule attached to it as to which persuaded the court to do what it did. So it was quashed solely on the basis of ground 2 of the claim, which was related in simple terms to procedural unfairness, yeah?
Yes, that's my understanding.
Yeah. And other grounds raised issues of apparent bias, some reasoning issues, approach to material considerations, none of which in the end led to the quashing of the decision.
They became academic.
Yeah, so none of them led to the quashing of the decision.
I mean, point 10 of the order, so you're probably familiar with it now, confirms that the claimant, which is the appellant in this case, reserved its position on grounds 1, 3 and 4.
Yes, and you see what the Secretary of State said about them as well.
And the first defendant, as in the Secretary of State, does not
Secretary of
concede
State,
on
quite an
those grounds.
important person to understand the views of for the
Yeah.
purpose of this inquiry.
Yeah.
And we'll come and look at a little bit more about what the Secretary of State thought about the inspector's decision in a minute. But so going back to my question, none of those other grounds led to the quashing of the decision, did they?
No, just one.
And the subject matter of ground 2, we can go to the detail if you want to be. It related to an email sent to the HSRA. I can't remember what that acronym stands for, but
South Residents.
Halling, thank you.
Oh, then never mind.
The HSRA explaining why the inspector had liked a post of a consultant for the appellant, which she did not copy into the appellant, and it was accepted by the Secretary of State that failure to copy in the appellant was a procedural error that should lead to the quashing decision. Now, to ensure the Secretary of State accepted the inspector should have told the appellant that he'd responded to the HSRA and given it an opportunity to make comments and ask him to reopen the inquiry, and failure to do so was a procedural error. Yeah.
In short, I think that's
the subject matter. All right.
Yeah.
Now, if we look at NID 1.4, please. So
response from the Secretary of State.
yeah, this is the response. It's the PAT response, pre-action protocol letter. It's the skirmishes between lawyers like Mr. Marici and myself beforehand and people setting out their stall before the formal court proceedings are issued. But you'll see that are you familiar with this document?
Well, fair enough. Less so insofar as obviously as soon as it went to a High Court challenge, the legal team took over.
Right.
I have looked at it before, but I'm not. But ask me what you want to ask me, and I'll see if I can answer it.
Okay, well, I'll take it. This is the setting out the Secretary of State's position to the proposed grounds. Okay.
Yeah.
And if you go down into the document, you will see effectively, if you've had a chance to read this, there's a concession made in relation to ground 2. If you look at PDF page 2, paragraph 8, sums it up. Paragraph 8 says the Secretary will concede the statutory review on proposed ground 2.
Yeah.
Again, accepts it's unlawful. And then paragraph 9 says, because of that, the rest of it's academic.
Yeah.
However, if you look at the paragraph 9, for that reason, second sentence, however, for the avoidance of doubt, the Secretary of State briefly explains why there is no concession in respect of each of the other proposed grounds. Okay?
Yeah.
So ground 1, Secretary of State doesn't accept as even arguable. It's a difficult starting position to extrapolate from the LinkedIn matter that the inspector displayed bias against the claimant. I can see the humour, dark humour in that comment. Moreover, the claimant is well informed as to what actions the inspector did take, on which basis a technical argument on what might have occurred is unlikely to succeed. And then grounds 3 and 4, Secretary of State does not accept the inspector's approach as unlawful. The reasons for the inspector's decision were legally adequate, must be read as a whole, etc., etc. So pretty clear, isn't it, that the Secretary of State that took the view the other grounds were not arguable, and noted that the various judgments made, so far as they were ones that were challenged, were not unlawful. Yeah, that's the Secretary of State's view. Now, Secretary of State may be wrong, but the Secretary of State's a person of considerable importance in the planning inquiry.
Yeah. So, I mean, I'm not a barrister, obviously, but I seek to read that if the
Right.
challenge had gone ahead and was heard in the court, then clearly the Secretary of State would have defended those grounds.
So, plainly, we know what the Secretary of State's view is, but in any event, the basis of the quashing, as I think we've both agreed, had nothing to do at all with the findings made by the inspector on the various issues relating to exceptional circumstances that he grappled with, did they?
They were related to procedural.
Yeah. And now, again, you tell me what you're understanding, but there's a bit of law, but when a planning decision is quashed, it is still, in some circumstances, capable of being a material consideration. I'll leave the submissions to law to others than you, but assume for the present purposes that we overcome that, which I know is an issue between us. And one of the reasons that if it becomes a material consideration that it might weigh in a balance of a decision maker is to do with what's known, and you will be familiar with this, I know, the principle of consistency in decision making. It's one of your favourite topics. And that principle is given effect in planning decision making with the test of material considerations. That's how it works in your world. And the weight you give to it is a matter of judgment, and there's lots of law, which I'm sure the inspector will have in the closing submissions from us both. But the principle of consistency in decision making, which is one you're familiar with, is one gets to the stage of it being material, is important. In other words, the members of the public don't have decision makers coming along one after the other and making different decisions, even if they're all matters of planning judgment. That's the materiality of it, isn't it?
But in broad terms, yes. I mean, it depends on what aspect of local or national policy the decision makers grappling
Sure.
with.
Yeah.
I mean, time's a factor too, because clearly national policy changes.
Yeah.
Excuse
me. Yeah. So, okay, but is that principle, because let me put it this way, and maybe cut matters short, because a lot of you do quite an extensive table. I think it's a combined bit of work with you and Mr. Smith.
Appendix 10.
The dream team. Yeah, and you go through and you do your analysis of why you think in many regards the inspector's wrong.
Yeah, I mean, I'm not in every regard.
No.
Sometimes it was a comment, sometimes
Sure.
there was certain aspects where we think respectfully, sir, that
Sure.
the other inspector got things wrong, yes.
But I suppose, let me put it, maybe I don't want to stray into legal submissions, but the point I'm really putting to you here, that if one gets to the stage of it being material planning consideration, and part of the importance is of the principle of consistency and decision making as a factor for this inspector to be aware of, forming his own judgment. It's not really a question, is it, at that stage, well, we think the last inspector's judgment was wrong. That doesn't meet the point about consistency and decision making. Do you see what I mean? That is a decision by an inspector that is material in this scenario, recently made, similar policy context.
I mean, the way I mean, obviously there's legal submissions on this, which I'm not going to get into, but you have regard to what the previous inspector said on a particular topic through the lens of what you've heard this inquiry in terms of the updated evidence. So, which is why we're completely rerunning the inquiry in my view, with new evidence, new proofs, everything. Obviously, a different inspector to allow this inspector to come to his own judgment
Yeah.
based on all of the information.
No, I don't think anyone disputes any of that, but I think we're also agreed that one of the issues between us is whether the materiality of the previous inspector's decision, I mean, it's literally is one of the issues identified in the statement of common ground, which is why I'm asking you about
Yeah,
it.
no, it's fine.
I get all you're saying, and no one's suggesting this inspector mustn't look at it afresh. But if he gets to the stage of this being, taking the view that this is a material consideration, which he should consider,
Mhm.
he might think it's not. But if he does, I'm suggesting to you that it would find force in this as a material consideration, and it would find forces under the principle of consistency in planning decision making, which is a well understood
Yeah.
matter of planning judgment, which is why I'm asking you about it.
Yeah, yeah.
And in that scenario, the fact that you might disagree with the previous inspector on, well, I don't think he got the evidence on landscape right, doesn't really meet the point, because the point is that's a decision, and it's important for consistency, for public confidence, that a different decision can be made, but one's got to think about it quite carefully before one does that. That's the point, right? Now, the reason why I think that's relevant, I'm going to put to you relevant here, because the inspector will see many of the letters written in make this point exactly. Why are we here again? Only a year ago, an inspector looked at this, had the joys of hearing you and everyone give evidence and decided against you. Why are we here again? And that's the importance of consistency in decision making, isn't it? That's how it finds force.
Well, I would imagine the inspector will wish to grapple with this in his decision. You know, first of all, have regard to the legal submissions on does the previous inspector's report
Yeah.
have any weight?
Yeah.
And then to outline and consider any change of circumstances or changes in evidence that has occurred since the last
Yep.
inquiry, in order to help explain to us all and the wider public the context to his decision.
Yes,
Be it to
and
allow or dismiss the appeal.
I agree. And we know this development plan policy context is the same.
Yes.
We know the scheme is the same, putting aside
Yeah.
allotments and bits and bobs, but essentially the scheme is the same.
Yes.
Yeah.
But sorry, apart from the two trees have gone at the side.
Your two trees. I'm not. Yeah. Okay.
Sorry, it's semantics, I know. But
No, not in your case.
Yeah.
And we know that there's no 5-year supply. You say it's a worse shortfall, but there was no 5-year supply before. I think we have agreed there's quite a considerable change in the national policy context in terms of the government's new approach to how and where housing should be delivered with grey belts and brownfield land. That's quite a change, isn't it?
Well, yeah, there's
Been
been
through-
a
been through
different
all that.
government and a different MPPF. Yeah.
Yeah, well, absolutely. Dividend PPF and some new references and PPG we've been through. Okay, good. I can make submissions on that. So 3:30, you asked, I think, for a pause and review at 3:30.
Yeah. How's it going?
I think, well, I won't comment on how I think it's going, so but I give you a time.
It was worth a try.
Don't tempt me. I'm very keen to everyone to get home, not least for me. So I think I could probably do in just about another hour.
Ignoring a break, that takes us to 4:30. Roughly how long have you got, Mr. Brown? 29 minutes. And there will be some re-examination. I know we're only halfway through or whatever it is, but is it going to be lengthy?
It's probably going to be about 45 minutes or so, I
Okay.
think, maybe a bit longer.
It sounds as though just about we can do it today if we run till 6 o'clock, which I'm happy to do. Honestly, not beyond 6 o'clock. A minute past, but really not beyond 6. But we do therefore need to leave this room. So let's adjourn briefly now, move to wherever we're moving to, and set ourselves up again and make sure that the live stream is working. So we'll adjourn for as long as it takes.
Committee room 1.
Committee room 1, wherever.